You're not going to believe this. Louisiana has a law that limits the amount of damages that an uninsured driver can recover in a car accident. It's called the no pay, no play statute, and here's what it does. Let's say you get in an accident. The other driver is completely at fault. You've been injured, your car's been damaged. You learn after the accident that your insurance lapsed or was canceled shortly before the accident. Maybe your ex was supposed to pay the premium. Maybe you changed your address and didn't get notice of the lapse of your policy. There are many situations which arise that cause well-intended folks who are able to pay for their coverage to somehow miss a premium payment and fall into this unfortunate situation. Under the no pay, no play statute, if you are in an accident through no fault of your own, but your coverage has lapsed before that accident, you will be made to forfeit the first $15,000 of your injury claim and the first $25,000 of your property damage claim. That may mean you're not able to get treatment for your damages, you're not able to get compensation for your missed work, you're not able to get your car repaired and get back on the road and carry on with your life. Over the next few minutes, I'm going to show you everything you need to know about this law so you can avoid putting yourself in this financially precarious position. My name is Chris Shouse. I'm a Baton Rouge personal injury lawyer since 1992. We've been helping injured crash victims get justice for their injuries. Louisiana's no pay, no play statute, RS 32866, was passed in 2011 to encourage drivers to purchase car insurance and reduce the number of uninsured drivers on the road. However, here's what it really did. Technically, the law states that the following limits be placed on damages paid in a no pay, no play scenario. As to bodily injury, uninsured drivers can't receive the first $15,000 of bodily injury damages. If your claim is worth $15,000 or less, you'll receive nothing. Property damage, uninsured drivers cannot recover the first $25,000 of their property damage. That means you're going to have to come up with funds on your own to repair damage and get your vehicle back on the road. If the uninsured driver is awarded an amount equal to or less than the minimum amount of compulsory insurance, here 15, 30, 25, they're liable for all court costs. There are exceptions to the no pay, no law, including situations where the other driver intentionally caused the accident, or the other driver fled the scene of the accident, as in a hit and run, or if the crash occurred while the other driver is committing a felony or is driving under the influence of drugs or alcohol. Note that no pay, no play would not apply to a passenger, a disinterested passenger who does not own the vehicle and therefore has no responsibility to provide insurance. What do you need to do to make sure you don't fall into this gap? First, make sure your insurance coverage remains in force. Stay in touch with your insurance agent. Let them know when you move, when you change address. Many folks rely on auto pay arrangements to make sure that their auto insurance premiums are paid automatically month by month. In a minor accident, no pay, no play may completely eliminate the claim. In a more serious accident, no pay, no play substantially impairs the value of the claim, but does not completely end the claim. I used to work for the insurance companies. I know their tricks and I know their strategies. That's the reason I no longer work for the insurance companies. When you work with our firm, there are no out-of-pocket expenses to you. We work with you on a contingency basis, which means if we don't win your case, we don't receive compensation. If you've suffered an injury through no fault of your own and the insurance company is pushing you around, schedule a time to meet with my firm today.